Good morning, everyone. We're here for oral argument in case number 1 CV18 0288 DABUSH et al. Versus SEACREST et al. These proceedings are being audio and video recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side has 20 minutes. Appellant's counsel, you're advised that if you want to reserve any portion of your argument for rebuttal, it's your responsibility to maintain that. I will let appellee's counsel be aware that you've both signed on, but you only get 20 minutes. I don't know who's going to go first, but if the first one uses all of the time, there you have it. All right? With that in mind, counsel, you may begin.
Good morning, and if it may please the court, my name is Justin Henry, and I am counsel for Ephraim and Rachel DABUSH, appellants in this particular case. As an initial matter, on this particular case, we feel like summary judgment was improper for the trial court because there was a myriad of questions of fact that were required to be resolved, and the trial court improperly did that in violation of Rule 56 and Orm School v. Reeves. For every witness in this case that says one thing, there is at least one or more witnesses that say the exact opposite. And it was improper for the trial court to even try and make a conclusion as a matter of law when there's inconsistencies in the record on material issues of fact.
My understanding of the record is that the skylight that broke in which Mr. DABUSH was injured was in a separate part of the roof than was being worked on by Prisma, correct?
No, I would not agree with that. It was not the specific skylight that was being worked on at the time by the Prisma employees. So the roof is a rectangular roof. There is a hatch that you access the roof through, and you have to walk by skylight number 10, which is what he fell through, to get to skylight number 18. So it's on the way there or on the way back, whichever way you want to look at it, as to the skylight that they were working on. But
well, my question is, if the employees are working on 18, 17, or whatever the numbers are, nothing is being done with skylight 10 at the moment. How is Prisma responsible for anything that happens with the skylight that your client fell through?
Well, I think the problem with looking at this case through that particular lens, Your Honor, is that you're talking about issues of breach. And the court, at the trial court level, ruled that there was no duty. And so you're using the facts that are specific to the particular case to decide whether they have a duty or not. And the Quiros case says we don't do that. We only consider facts before any action or inaction of the defendant, which may or may not have placed the person in harm's way.
If Prisma was hired to work on the skylights that they did, what duty would they have to the other skylights? Was that an issue?
It was an issue. Prisma was hired to fix all of the skylights, not just skylight 18 or 14 or 12. They were hired to fix all of them, and so it wasn't the activity that they were involved in was to stop the leaks on the roof, and their goal in doing that, in reaching that solution, was to replace every skylight on the roof. And they testified that it was their intention to replace every skylight on the roof. And so when you're talking about whether Prisma owed a duty to Mr. DABUSH, and you look at Restatement Section 383, what it says is, if they're acting on behalf of the possessor of land, which they clearly were here, that's undisputed that they were hired to do this job, they take on all of the duties of a possessor of land. And so if you look at the Wynn versus Wynn case that was cited in the briefs, when it talked about the duty, it talked about the duty vis-a-vis whether it was an invitee or a licensee. And that's what the duty we're talking about here that should have been applied to Prisma. And if you start breaking it down by areas of the portion of the roof, that's not how a possessor of land's duty works. So in this particular case, for example, we take the position that Ephraim DABUSH was an invitee. The duty that would apply to an invitee as a landowner or possessor of land, which is going to be applied to them.
Before you keep going, I just want to make sure I understand factually. Skylight number 10.
Yes.
Other than walking by it, had they done any work on skylight number 10?
On that day?
Any day.
Yes.
Where in the record does it cite to me that they had done anything as it relates to skylight number 10?
So Omar Unzueta and Valentin Navarez were the Prisma employees that were working on the roof on behalf of Prisma. And what they had testified to is that they had tried to fix the skylights by putting tar on all of the skylights in an attempt to seal up the cracks. And that was in their deposition testimony. It didn't work. They did that because Ephraim DABUSH is the one who told them that's how they needed to get it fixed. And so after they did that, they decided we need to replace all of them.
Some work.
They did some work over the whole roof. And they were
Did it have anything to do with the fall?
The work that was done? I don't know.
Improper applying of tar was the cause for the roof, the skylight to collapse when he stepped on it.
I don't know. That would be a question of breach, Your Honor, as opposed to a question of duty. And that was the only issue that was before the trial court was, did they have a duty? So the questions we're getting into all have to do with, did they breach it? Were they the cause of the injury? And those are questions that are outside the province of duty. Duty only has to do with what is the relationship.
Are we reviewing this de novo? Doing that, we review it on any assertion that would affirm the trial court's ruling.
I don't believe so. I think I get that. I get that a trial court can be affirmed for any reason that's supported in the record. But when you're talking about issues that were brought as a result of purely on duty, and the entire briefing in the case was limited to duty rather than to whether a breach occurred, it would be unfair to get into issues of breach, which evidence was never presented. If a plaintiff or any party on opposing a motion for summary judgment had to go and prove and provide evidence of every facet of its case, even though the issue was never even raised.
You're not seriously standing there before us arguing that somehow the placing of the tar around skylight number 10 was a cause of the skylight to collapse.
No, I'm not making that argument. What I could say is I don't know. I think
other than placing on the tar and then walking by it, was there any indication that they had attempted or started to work on skylight number 10?
With respect to replacing it, no. But again, the duty is not solely limited to what they did. The duty is the same as a possessor of land as long as it involves the act or activity that's being conducted on the property. And that's what Ephraim DABUSH was on the roof for the work.
Let's talk about that a little bit. First of all, can you answer this question? Who, in your opinion, controlled the portion of the roof at the time the injury occurred? Direct or Prisma? Am I saying that right? Prisma.
Yes. Both.
And how did Direct control the roof?
The testimony in the record as to Direct's level of control of the roof is that David Ben Shabbat, the warehouse manager for Direct, sent Ephraim up to the roof, asked him to inspect the skylights, asked him to take pictures of the skylights, asked him to provide his professional opinion on what additional work needed to be completed on the skylights, all because he stated in his testimony that it was his responsibility as Direct's warehouse manager to make sure that the maintenance work was completed.
Okay, so let's go on to...
There's more.
I get what you're saying. What I'm trying to figure out is David Ben Shabbat was Direct's principal. Gottlieb was also Direct's principal. Gottlieb says, Prisma, do this work for me. and because they're all in the same location, Ben Shabbat says to Mr. DABUSH, go up there and check and see how they're doing. So he went up at the direction of Direct, not at the direction of Prisma. Would you agree?
I would agree.
So when we're looking at duty, how does Prisma have a duty to him?
If you look at the comment to the restatement, section 383, it specifically addresses this issue and says that Prisma, as the one doing the work and is in control of that area of the property, has a responsibility to anticipate that people may get sent onto their property.
There's something different there. This is a roof. People don't wander across a roof, okay? It requires access inside a building to a ladder and a hatchway on the roof. You would agree with me that no person that's just there to, say, buy beauty products or whatever in the heck they sell is going to wander on the roof.
I would agree.
So when we talk about anticipation, let's not talk about it in that kind of way. How on earth would Prisma have anticipated that Ben Shabbat was going to send Mr. DABUSH up there to check on their work?
Well, let's look at the facts that lead up to it. You have testimony from Omar and Valentin that Ephraim DABUSH was not on the roof on one occasion only, that he was intimately involved in all of the repairs, that on previous occasions he was on the roof. He's the one who told him to tar the skylights. He'd been there before and was involved in the work. Omar and Valentin also testified on the day of the incident that Ephraim DABUSH was involved with moving materials up to the roof so they could complete their work. And then after that, Ephraim took some pictures of Skylight 18, which they started working on, started walking away, went down to Skylight 10, and that's when he ultimately fell through. They were acutely aware that he was on the roof throughout the course of this entire process, and even on previous days in participating and in fact directing and overseeing the work that they were completed. This is not a situation where some guy just showed up one day, they had no idea who he was or what was going on. And then on top of that, he talked to them first. They knew he was up there. It's not like some guy walked up, they were working, they were concerned with what they were doing, and some guy just fell through a roof. He was working with them, working to get the job done that they were hired to do, and as he's inspecting another skylight, he gets hurt. It's directly related to everything that Prisma was doing on the roof.
Let's start with Spa.
Sure.
Spa is the wholesaler, Direct is a distributor, Prisma is a real estate investment company. David Ben Shabbat ran Direct, Iliad Gottlieb ran Spa, and Prisma. Okay, so this is where it's really difficult, and I diagrammed all these parties to make sure I understood the interrelationship, and I still do not. So,
welcome to the club.
Ben Shabbat is the primary of Direct.
Which Ben Shabbat? Are you talking David?
David Ben Shabbat.
David has zero ownership interest in Direct.
He just runs it?
I would tell you that he runs all of them as the patriarch of the family, and that's how the testimony was presented. His sons own various portions of Spa and Direct and Chambers. Elad Gottlieb owns part of Prisma. He owns part of Spa. He does not have an ownership interest in Direct at the time. I believe he bought in later. It's really complicated as to how everything works, but David Ben Shabbat does not have an ownership interest in anything. He is the warehouse manager for Direct. He also happens to be the father of all of the principals of the various companies, which is not an insignificant fact in this particular case. This is an Israeli company, and culturally and religiously, he holds a very important position with respect to everyone, and he essentially runs the show, is the testimony that was presented at deposition.
Okay, and I get that he's the guy, but when we talk about the guy, let's talk about, at his direction, a Prisma employee would do whatever he said.
Correct.
A Spa employee would do whatever he said.
Correct.
A Direct employee would do whatever he said.
Correct.
And so the management of all companies or the warehouse facility was overseen kind of an umbrella under Spa by David Ben Shabbat.
I don't know that that's true. I mean, David Ben Shabbat wasn't a spa employee, and I think that's
all of these are subleases. All of that. It all starts at the spa.
Chambers actually was the owner of the property.
They've got a lease with spa. It all trickles down from the spa.
Agreed. But when you're talking about a motion for summary judgment and resolving, say, which entity that David Ben Shabbat sent him up to the roof on behalf of, given that dynamic, you can't say as a matter of law he was acting on behalf of SPA. And certainly you can't say as a matter of law that he was doing it when he specifically testified he was doing it on behalf of Direct. And that's where the trial court went sideways on this, is that the court said, well, he sent him up there for the benefit of SPA. That is certainly an argument that can be made at trial, but a reasonable inference from it, especially when he specifically testified he did it on behalf of Direct, is not that he was acting on behalf of SPA. It's that he was acting on behalf of Direct, and they were exercising their control over that portion of the property.
And at that point in time, was David Ben Shabbat exercising any control over Prisma?
I don't think so. I mean, he obviously has the ability to instruct the employees as to what to do, but his control over Prisma, I don't think, is necessarily relevant to the issue of whether Direct had a duty or whether Prisma had a duty.
I think it has something to do with it. So talk to me about that.
Well, David Ben Shabbat has the authority to control anybody at the warehouse. And so was he exercising control over Prisma at that time? I think that there's a reasonable inference that that is true, considering that if you look at Prisma's brief in and of itself, it says that when Ephraim Ben Shabbat, or Ephraim DABUSH, gets up to the roof, he's directing how Prisma is supposed to be doing their work.
So here's the question. DABUSH is employed by Direct.
DABUSH is not an employee at all. His son is a principal in Direct.
So,
who's he working for?
He's not working for any of them.
So as a volunteer, he went up on this roof. And I think that is a major point that we have not ferreted out.
He was not a volunteer.
What is he?
He's a gratuitous employee. He was working at the direction and control of David Ben Shabbat. This isn't a situation where a volunteer is someone who just shows up and starts helping. The big distinction between the two is he was specifically asked to do something, and that submitted himself to the direction and control. This goes to the Bond v. Cartwright case, where he goes up, and they didn't say, can you just go up to the roof, see what's going on? He gave him very specific instructions. Said, go up to the roof. Take pictures, see what they're doing. Bring me your professional opinion as to what additional work needs to be done. He was operating under the direction and control. The second part of the gratuitous employee test is that there needs to be an interest involved. And that interest is very minimal. So in Bond v. Cartwright, the only interest that the plaintiff had in that case was that his son was part of the Little League. Oddly enough, that's very harmonious with this, in that Ephraim's DABUSH's son is one of the principals at Direct. So he had an interest, which makes him a gratuitous employee at the time, and they had duties flowing from that because they sent him to the roof. And that's the public policy part of this that goes with the conduct of Direct in sending him up to the roof. They sent him into an area of danger. They owed a duty, and that's in the Bond v. Cartwright case, and they quote the Chamberlain v. Handpaw from, I think it's Michigan, where they're saying, if you send someone to a place of danger, you need to make sure it's safe for them, and they didn't. And again, these are duties. The only thing we're here to talk about today is, did they have a duty? Breach, where was it? Did they do anything? Those are all breach issues that are not appropriate for consideration at this time, because we're only talking about duty. Thank you.
All right. Thank you, counsel. Counsel for appellate.
Thank you. Good morning. My name is John Barnes. I'm here for Prisma Capital, LLC. I'm sharing my time this morning, so I'm going to try to be brief. I only have 2 points. First, the risk of falling through a skylight was the same before, during, and after the time that Prisma workers were present on the roof. They didn't do anything to create or increase that risk of falling, and therefore didn't assume any duty to safeguard others from it. Second, there's no evidence in the record showing that Prisma assumed the role of a general contractor by taking charge of the entire roof. There's no evidence that any of the warehouse tenants surrendered control of the premises to Prisma as though it were a general contractor.
So, in your opinion, who controlled that portion of the roof at the time the injury occurred?
So we're talking about duty, and under the Key Rose case and the Gibson case, we're looking at a statute, a contract, a common law relationship, or conduct. Well, there's no statute or contract at issue here. So we're looking at the common law relationship, and that would be the landowner, invitee, or licensee relationship, and that flows up to SPA as the landlord and as the financier of all warehouse operations, essentially all warehouse maintenance.
So Prisma had no control over that roof at all.
Well, I mean, they're in control of their own work, right? But the restatement tells us that a worker doesn't assume a duty with respect to work he hasn't gotten to yet, unless he created the danger in the first instance, which we don't have any evidence of that here.
So is your argument that they controlled the work on the roof, but they just didn't owe a duty as it relates to the areas that they hadn't gotten to?
That's right. At the end of the day, this is two workers doing one skylight at a time, and they didn't assume any duty with respect to other parts of the premises. And so going back.
Well, but they did do some work on skylight 10, correct?
Well, so my understanding is there was some work laying down some tar days or possibly even weeks before, but no one has argued in the trial court or on appeal that somehow created a duty or created the risk of falling through the skylight here. Going back to the Wynn case, if I could just briefly, in that case, what gave rise to the duty was the woman's conduct in waxing the floor, and then someone slipped on the floor. I think what plaintiffs are trying to do here is analogize with that case as though, pretend somebody had fallen in the backyard of that house where the kitchen had been waxed. Waxing the kitchen floor didn't give rise to a duty to safeguard people from falling in the backyard. And that's sort of what we have here, is working on the one skylight that Prisma was working on didn't give rise to duties to safeguard others from other aspects of the premises. They didn't take control of the entire premises. Unless there are any other questions, I'll yield my time to Ms. Rosen.
Before you sit, counsel, explain to us, I'd like you to, and it's address the gratuitous employee, that DABUSH was a gratuitous employee of Direct, or was he a gratuitous employee of Prisma? And what is David Ben Shabbat? This is a pretty interconnected kind of business relationship. We don't have those clean lines. You work for him, you work for him. We all work in the same building.
Right.
The same guy tells us what to do. How do you get over all of those kinds of issues when we're talking about just the threshold of duty and there not being some sort of fact at issue?
Well, frankly, Judge, I don't think that that's material for the issues concerning Prisma, because we're looking at Prisma's relationship with Mr. DABUSH. And so there was no relationship here. Whether Mr. DABUSH was working for Direct or SPA or anyone else in the warehouse, I don't think that changes the dynamic with Prisma.
All right. And if Mr. Gottlieb had sent Mr. DABUSH to the roof, we'd be in a different position?
Then we'd have to, that would raise issues, in what capacity did he do that, whether he was doing that on behalf of Prisma or on behalf of SPA. But again, there's no indication in the record that ELAD had anything to do with sending Mr. DABUSH.
But what there is evidence in the record of is Mr. Ben Shabbat acting on behalf of Mr. Gottlieb when it comes to maintenance and repair of the building and the portion of the building that Prisma, quote, rented, which is not easily ascertainable or identified. Mm-hmm. So when we talk about that, is that a facts issue that would preclude summary judgment on the issue of duty?
I don't see how that has any bearing on the issue in this case, just because whatever David did, there's no evidence showing that he was doing that in some official capacity on behalf of Prisma. He has no connection to Prisma, right? So all the evidence shows is that he would kind of just give orders. He would just do things without asking anybody. And so to then use that to impute a duty to someone who didn't consent or didn't sanction any of those orders, I don't think that there's any basis for doing that.
So if Mr. Gottlieb was complicit in allowing Mr. Ben Shabbat to override and direct his employees, does that create a fact issue that we need to address?
Again, I don't think so, because at the end of the day, what we're talking about is two employees who didn't have control of the situation. They followed the orders whoever gave them. And because we're not talking about a statutory duty, we're not talking about a contractual duty, we're not talking about the traditional common law landowner relationship duty, we're talking about conduct. And so it's control that leads to a duty, not vice versa.
And I posit this to you, counsel. It's a roof. You can't get there normally. Nobody's going to happen along to it. When we talk about control of the roof, who controlled the roof?
The landowner.
And that's okay. Thank you.
Thank you.
All right, thank you.
Morning, Your Honors. My name is Lou Ann Rosen, and I represent Secret Direct. And I think two issues that you've hit on are very important. One is that David had no legal authority to direct anyone to go up on the roof. He was not an owner of any of these companies. He was a direct employee, and in his capacity as a direct employee, he was basically the manager of that portion of the warehouse that Direct leased from SPA. And Chambers was the landowner. Chambers leased the entire premises to SPA. SPA kept part of the warehouse and sublet a portion to Direct and a portion to Prisma. And
So just so we're crystal clear, David directs Mr. DABUSH to the roof.
he asked him to go up and take some photos and report back so that he can...
It was more than just go and peek. I mean, there was specifically go up there, take some photos, let me know how it's going, whether or not, in your professional opinion, they're doing it right,
Correct.
et cetera, et cetera.
So he could report back to his son. Not for his own personal knowledge, but then he wanted to impart that to his son, who is the SPA principal. And SPA is the entity here who, through Eli Gottlieb, who asked Prisma, he's also principal of Prisma, and asked Prisma to do the work.
But given the relationship between all of these parties, aren't we splitting hairs on saying, oh, he was doing it not as a direct employee? I mean, isn't that basically what you have to argue?
Well, it's a family relationship, and what the trial court found, which I think was correct, is that SPA, as the owner, can give a lessee the authority to go on the roof and the authority to allow other people to go on the roof. That's what the trial court found. And the trial court found that Direct did not have the duty here to Ephraim because David was acting basically on behalf of SPA, not on behalf of Direct.
But isn't that a factual question?
Well, I don't think that it is because of the contracts that are at issue here. So the contract between SPA and Direct is a little bit different than the contract between SPA and Prisma, and I think that the one between nobody's arguing at all that Prisma has control over the entire premises. So they have a similar contract to the contract between Chambers and SPA, where it's more open-ended. The contract between SPA and Direct says that Direct only has a certain portion of the premises which is to be determined. It was later determined, and it's actually delineated by a chain link fence. So
Within the warehouse, but nothing on the roof.
correct, within the warehouse. And all of the case law, the Martinez case, and then we quoted several out-of-state cases because there is not a specific roof case in Arizona, but all of the cases say that when whether it's the owner or the landlord who's leasing from the owner, when they retain part of the premises and just lease out other parts to other entities, the landlord retains control of the common areas and areas like the roof. The roof is there for for everybody who's a tenant of the building. It's not there, you don't say, okay, Direct, you need to take care of this part of the roof, and Prisma, you need to take care of this part of the roof because it's over your part of the warehouse. At the trial court, we used an example of an apartment complex, and there are several apartment cases, but there are also cases from other jurisdictions that apply it to commercial leases, where you wouldn't tell your tenant in Unit 3B, well, you've got a leak over your portion of the roof, you need to go fix it. No, the building owner or the landlord fixes that. It's not each unit owner doesn't have the obligation to fix the portion of the roof over there.
It's a little distinguishable, not a little, it's a lot distinguishable in this case because Direct's employee, and there's no dispute, directs Mr. DABUSH to the roof and to engage in activities that arguably would benefit Direct, or they clearly would benefit SPA. So,
that's true, and I think the difference here, and you had asked about the gratuitous employee, is that under the bond case, he's not a gratuitous employee because he himself, Ephraim, does not have an interest in the building or an interest in the roof, and that's part of the bond case. You need to look at, does the person who's taking the action have an interest in the work that's being done?
And doesn't the fact that his son owns part of Direct give him a relationship where he does receive benefit, if nothing else, through his son being successful?
I think that's a little extenuating, but I suppose that it does to a certain extent, or could.
Okay, so if we accept, for the sake of argument, that Mr. DABUSH was a gratuitous employee, based on the fact that David Ben Shabbat is the one that directed him, do we have any idea on behalf of which entity he directed him to go to the roof? I mean, it seems to me that Mr. Ben Shabbat was wearing 8 different hats at any given day, and there are legal relationships and then there are conduct relationships that develop over the course of a business. And if, having worked on a family business, my dad told me to do something, it didn't matter what it was or who I was doing it for, I was going to get it done. So when we talk about Mr. Ben Shabbat being kind of the head of everything, the owner of nothing, how are we supposed to differentiate the duty he owns when he puts on different hats? Because he looks the same.
He does look the same. He does, but he's not employed by SPA. He's not, as SPA is the owner. He's employed only by Direct, and he doesn't have an ownership interest in Direct or SPA. He is, I would say that Direct does not have the legal ability to repair the roof. So if he sends somebody up on the roof and he's doing it, he can't do it for Direct because Direct doesn't have control of the roof. You have to look back again at who has control of the roof, and that's SPA.
In your opinion, SPA's the only one that had control.
That's correct.
Sorry, Reed.
So that's not a fact. I mean, you may be correct in your statement about the relationships, but aren't those factual questions to be? I
don't believe they are. The trial court decided it as a matter of law, and I think that this court in a de novo review should decide it as a matter of law. There's no contractual transfer of that right to Direct. There's no the owner of the premises or the landlord of the premises retains control of the roof and the other common areas, and they can authorize other people to have people go up on the roof, and they can authorize David to let other people go up on the roof. But that doesn't give David the right under Direct to authorize people to go up on the roof. Direct doesn't have control of the roof. So David,
as the person that runs Direct, gives pretty specific instructions to Mr. DABUSH to go up on the roof and the only thing that he is directs, based on what you've just told me.
Correct.
Principal. How does he not have a duty to ensure his gratuitous employee, for the sake of argument, is safe? How does he not have a duty to him when he's the one that sent him on the errand?
Because he's sending him on the errand on behalf of SPA, not on behalf of Direct.
And forgive me for separating, but isn't that a factual question? Whether he did it on behalf of Direct or if he did it on behalf of SPA?
Again, I think you would need to look at the case law and the restatement and the Martinez case and the all of the law that says that the landowner retains control of those areas, not a specific tenant. And the landowner can give a tenant the ability, as happened here, to allow somebody else to go up on the roof. I would also ask you to take a look at the bond case more closely, and where they have a definition of the volunteer. And I would say that Ephraim DABUSH went up on this roof as a volunteer and not as a gratuitous employee. And
just because he wasn't getting anything in return?
Correct. He wasn't getting any payment. He wasn't, and he didn't ask, David didn't ask him to go up and work on the roof. He asked him, go up and take a look and let me know what they're doing. They were there, they were going to go to lunch. David says, can I do anything? Ephraim says, can I do anything? David's like, yeah, go look up on the roof and see what these guys are doing and report back to me so I can tell my sons who work for SPA.
When we talk about work, part of a contractor's job is to supervise, and it sounds like that he went up there to supervise what Prisma employees were doing on behalf of Direct. How is that wrong?
I don't think he was supervising what they were doing on behalf of Direct. I think he was looking at what they were doing. I don't think he was giving them directions. It wasn't Direct that was fixing the roof. It was SPA who hired Prisma to fix the roof.
Didn't Mr. DABUSH tell them to put the tar around the different skylights?
I don't know that. I heard that in the record today. I don't think that relates to Direct, because if he did that, it was not at the direction of Direct. I don't think there's any evidence in the record that
David didn't direct him to do that. I thought
all of the
conversations were between David and Mr. DABUSH.
I don't know that that's necessarily correct, but
Who else would have told him to go up there? I mean, if you don't know, you don't know, but who else would have told him to go up there and do that kind of activity other than David?
I don't know. I don't know if Elad would have. That's possible. I don't know the answer to that question.
And if we back it up, you encourage us to reread the bond case. And volunteer versus gratuitous employee. How is that not a factual issue?
Well, I think that in this case there really is no evidence that he was a gratuitous employee. He wasn't asked to go up there and perform work on the skylights, if you will, to fix anything. He was asked, David asked him, I would say on behalf of SPA, to go up and take photos, come back and tell me what's going up on the roof so I can tell my sons what's happening. Not so that I can fix it or that I can tell Prisma what to do.
And I think we're having a little issue there. If he hadn't had construction experience, Mr. Ben Shabbat would not have sent him to the roof. So when you send him to the roof to take pictures and see what's going on so he can tell his sons, how does that not work?
Well, I guess then if it is work, it's on behalf of SPA, not on behalf of Direct, because David's only ability to send anybody up on the roof is on behalf of SPA, because Direct does not control the roof. So I would say if that's a fact question, it relates to SPA, not to Direct.
And the reason that Ephraim does it is indirectly to benefit his son, who is a principal in one of the businesses.
It's possible. I don't know why he went up on the roof. I don't know if that was a factor. I don't think it's in the record that that's a factor.
Is that relevant to whether he's a gratuitous employee or not?
It could be.
Then isn't that a factual issue?
Well, again, I would say it's a factual issue as to SPA, because Direct didn't have control of the roof. Anything that David sent him up to do was on behalf of SPA, not on behalf of Direct.
I believe you have a couple more questions.
Sorry, I just want to make sure I understand before we let you go. So, Ben Shabbat did not have any interest in SPA, was not an employee of SPA, had no contractual relationship with SPA. Is that correct? He just
Direct had
I'm not with Direct, with SPA.
No, Direct had a contract for a portion of the premises with SPA.
That's a lease. That has nothing to do with what he's doing walking around directing people, which is kind of difficult because your client's Direct, but directing people to do certain things on behalf of certain entities, the only one of which he has any interest in is Direct. Is that correct?
Employed by Direct.
So when we say he did that on behalf of SPA, is he a volunteer or a gratuitous employee of SPA?
No, he's a lessee of SPA, and a lessor can give a lessee the ability to go on other premises, and a lessor can give a lessee the ability to let other people, like Ephraim, go on other parts of the premises.
Andy, did you? All right, thank you, counsel.
Thank you.
Mr. Henry.
Short on time, so I'll try to be brief. And Judge Campbell, I want to address your issues. The focus for Direct,
issues.
The issues that you raised. The argument from Direct appears to be solely related to legal control. There's two forms of control, legal and actual control. Everything they talk about is the leases and what the leases provide. If they are actually exercising control by directing the type of repairs that are going to be done, making the decision as to what type of repairs are going to be done, actually up on the roof, and there's testimony in this case that David Ben Shabbat was on the roof directing the work that was to be done, they're exercising control, whether they're legally allowed to or not. In the Sanchez v. City of Tucson case, that's what happened. City of Tucson had no legal right to change anything at that intersection, but they exercised it anyway through a joint effort. Multiple parties can be in control of a property, and that's what happened here. And Judge Howe, it is a fact question as to whether he was sent up by David Ben Shabbat on behalf of SPA or Direct. And I'll tell you, David Ben Shabbat said he sent him up there on behalf of Direct. But it is a fact question for the trier of fact to resolve. With respect to Prisma, there was some argument that there was never any relationship between DABUSH and Prisma. That is not accurate, and that is a not accurate statement of the record. There's two versions of events. One is that David sent him up there. The other one, which is completely separate and cannot be reconciled, so one of these is true and one of them is not, is that he was actively involved with Prisma on all of their repairs. When they were hired to paint the floor, he was involved and he was directing Prisma's work. When they were hired to paint the offices, he was involved in directing Prisma's work. When they were cleaning the roof and caulking the roof, he was involved in directing their work. On the day of the accident, he was directing how they got their equipment up onto the roof. He was directing what repairs they were doing. He was involved intimately under that scenario of events with Prisma, and they owed a duty to him when he was up there under their restatement, and the fact that he is directing and overseeing their work, and they need to protect him when he's up on that roof, whether he's specifically working on Skylight 18 or as part of his function of running the whole site and telling Prisma, hey, we're going to work on this one next because it needs to be fixed. That's Skylight 10. That's what he was doing.
Counsel, thank you very much for your argument. Thank you for all of your arguments. They were very well done, and we will take this matter under advisement and issue a decision in due course.